case today that considered two issues that come up in business divorce lawsuits involving limited liability companies. The first is the question of what. What does one side have to show to have a member expelled? The second question is when. If there is an expulsion, when does that expulsion take effect? This is important because a lawsuit to expel a member, something that is known as involuntary dissociation, can sometimes take a significant amount of time. We're going to talk today about a case that's a few years old, but it's interesting in the way that it explored these issues. It's Headfirst Baseball versus Elwood. It's a very well-known case that came out of the District of Columbia. In that case, the court entered an order expelling one of the members based on his breaches of the limited liability company's operating agreement. The win is that the expulsion was effective as of the date of the filing of the lawsuit. You're listening to Closely Held. My name is Jay McDaniel. I'm the head of the Business Divorce Litigation Group at the Wiener Law Group in New York and New Jersey. Please take a moment to subscribe to our channel and to like or comment on this video. Helps us to get noticed and to get the information out to others. If you have any questions about the subject matter or have a case that you think you'd like to talk to someone about, feel free to contact me. My information is below the video. So here are the facts. A gentleman by the name of Brendan Sullivan and his friend, the defendant Robert Elwood, were members and 50% owners of a limited liability company called Headfirst Professional. These businesses prospered, but they descended into a bitter legal fight among the owners, a legal fight that got lots of press at the time. The evidence was that Elwood, for several years before 2012, had made purchases using company funds and took withdrawals from the various entities of approximately $175,000. Elwood contended that he had an agreement with Sullivan to use those funds for personal expenses. Elwood also loaned himself $600,000 from the businesses. Sullivan purported to terminate Elwood, contending that he was required to do so by a morals clause, had an agreement with the Red Sox professional baseball organization. Elwood then retaliated by cutting off access to the company's Google AdWords account and getting a freeze on the company's funds in the bank. The court held that while Elwood may have committed the acts complained of, the plaintiffs had failed to show that the company actually suffered any harm. Having rejected the claims over the money, however, the court went on to consider whether the plaintiff had established grounds for expulsion. They had to show that Elwood engaged in wrongful conduct that adversely and materially affected the company, or that he had willfully or persistently committed a material breach of the operating agreement, or that he had engaged in conduct relating to the company's activities that made it not reasonably practicable to carry on those activities with him continuing as a member. Those are the essential standards for expulsion under the Uniform Limited Liability Company Act. The court rejected the claim that Elwood had adversely and materially affected the company, but it did find that he could be disassociated for having willfully and persistently breached the operating agreement. The issue of when a judicial dissociation will be deemed effective is a fact-sensitive inquiry. The timing of the suit, the court held, indicated that it was not the misappropriation that triggered the attempt to expel him, but rather his acts of sabotage after he was fired. The timing, the court held, suggested that the filing of Headfirst Professional's lawsuit was prompted not by Elwood's conversion of funds, but by his post-termination acts of sabotage, which occurred shortly before the plaintiff filed suit. This may not seem like a matter that is of critical importance, but the date of expulsion can have significant financial consequences. Thanks for listening. Don't forget to subscribe, to like or share the video, and reach out to me if you have any questions or have a case that you want to talk about. Thanks again.